defense, and it deals with photographs, and the state has instructed me that there was numerous photographs that they had access to, and they have narrowed it down to the ones they're going to proffer in response to the motion in limine, and I've asked them to share those with the defense so that we can get specific objections.
Just for the court, here's the case law we're relying on. We've given it to tender group. And Your Honor, my understanding of the law is our motion deals not only with the autopsy but crime scene photographs. My understanding was that the state was going to attempt to offer some of the crime scene photographs as well, depicting somewhat of the same issues that we have the issue with. So,
I believe we have one of room 112 that involves victims.
Okay. Well, I need to let's get specific and actually show me the photographs, and then I can make rulings. So it's your motion, so you want to go ahead and proceed after you've reviewed what they've tendered to you?
yes, Your Honor. I mean, I could honestly, I could start now.
Okay.
And my co-counsel can review. I can start now because we are not, the substance of our motion is not that that some would be okay but others not. The substance of our motion is that none are okay. And so, if you'd like me to start,
yeah, please.
So, as the court knows, and the law has been pretty well settled for a long time, that a defendant who causes some sort of gruesome injury or death cannot be shielded from his actions under Rule 403. Our argument here, though, is that our client, the person on trial here, did not cause any of these injuries. He did not. Salvador Ramos caused these injuries, and he is not the person on trial. I only say that to start because that is it's one of the things that as litigators and criminal litigators we're used to is having that I guess that axiom of law. But in this particular case, and it's a very specific and different case, Adrian Gonzales did not shoot any child, did not kill any child. Now, what he's charged with is endangering. The endangering does not actually require, and in the elements, does not require them to prove that there was ever a death, right, or to prove that there was ever any injury, because as far as an endangering goes, it's not an element of proof that they have to make. Now, we agree, and we will stipulate that all of the children that are in the indictment were either killed or injured as listed in the indictment. It's not any matter of disputed facts. And one of the cases that we talked about in the motion in limine is Erazo versus State. And Erazo is particular. The language of Erazo is that an autopsy photograph they're not admissible solely to show that a person died. And so their language is, in other words, the relevance value of a photograph is to show appearance. The appearance of the dead fetus in this case was irrelevant. A crime scene photograph or an autopsy photograph is not admissible simply to show the death of the individual. Our position is that's all that these are. That's all they have relevance, is to show the death of. So now we're asking the court to do a 403 balancing test. The probative value in light of a stipulation is low, is extremely low. All they need is to show something that is not in dispute in the first place. But the prejudicial danger, as the court has viewed these photographs, the prejudicial danger is extremely high. This was a tragedy. And when we talk about prejudicial danger, does the court have some concern that it could affect a juror irrationally, to where the juror is not rationally basing a verdict on the actions of the defendant and whether or not the defendant committed the crime, but basing their verdict on the horrors of the photo? Again, we go back to the fact that Adrian Gonzales did not take a firearm, did not shoot any one of these children, We know who did cause these injuries and the deaths of these children. And so we're asking that the state not be allowed to do that. Now, I also know that in the law there is, it is typically that the state does not have to accept a stipulation from the defense. However, there are some exceptions to that. One of the exceptions is found in Temez, which is kind of a classic case, and that was a DWI case where the person had 9 prior DWIs. The defense was willing to stipulate that, hey, he's been previously convicted twice before to get to the felony jurisdictional aspect. And the court said, the prosecution at the time said, we don't have to accept that stipulation. They went ahead and put on 9 DWIs. And the court came back and reversed and said, look, there is no probative value in light of a stipulation that's going to establish the issue that you want to establish in the first place. There's only prejudicial danger after that. There's also a federal case, Old Chief, which dealt with the felon in possession of a firearm. Felon in possession of a firearm, the defendant in that case had been convicted of a sex offense against a child. The defense was willing to stipulate that he had been convicted of a felony for the purposes of felon in possession of a firearm. The state said, we don't have to accept the stipulation, and went ahead and presented the fact to the jury that he had been convicted of sexually assaulting a child. And the court came back again and said, at some point, if the prejudicial danger is so high and the probative value is so low, we do have to accept a stipulation in that sense. This is not an issue in contention or dispute. No one is disputing that Salvador Ramos went into this classroom and killed 19 children and injured 10 others, as well as killed 2 adults, which is not charged conduct here. No one's disputing that he did all of those things. So since there is no dispute, showing gruesome, horrible, heartbreaking photographs to the jury, simply and merely to prove that the individual died or was injured, is kind of a foundational, fundamental 403 balancing test. I can think of, and I don't know if the court's seen any, but I can think of nothing that I have ever seen more prejudicial than these photographs, ever. And the probative value that the state is proffering can only be, because he didn't do those things to those children, it can only be to show that the children have died or were injured. And that probative value is incredibly low in light of the fact that that is not an issue that's ever been in dispute. As the court pointed out, we tried to address in voir dire, but the way we addressed it is they will hear injury and hear about it. We agree that the state can elicit testimony. So they don't even have to accept our stipulation. They can elicit testimony. They're obviously free to do that from any of the witnesses and the medical examiner and everybody else that the children suffered injuries. And even they can detail the nature of those injuries. That will establish as well their element. But as far as these photographs, they are so prejudicial, and the danger of that unfair prejudice affecting the fundamental constitutional right of the defendant to due process and to have a fair trial is great. And so on that issue, we are asking the court to exclude any photographs of any child who has died as a result of these injuries or has been injured as a result of this, and limit the state merely or only to the stipulation by the defense or in addition to the stipulation, because we are stipulating and will stipulate from the beginning, but in addition to that, testimony from the relevant people as to the injuries if the court believes that that's what's needed to prove the element of placing the child in danger of death. So I guess on that issue, there are some other issues in the motion, but on that issue, I will pass to my opposing counsel. Judge, there was one more issue when you're ready for me that I had forgotten to address that I'd like to before opposing counsel does.
Okay, go ahead.
But it's just that since the court has now seen the photographs, where these children were shot were not decisions made by Adrian Gonzales, how the children were shot. Some of those photographs are particularly gruesome, especially some of the injuries, but all of them are horrifying. Will be horrifying to a jury. And there's one more issue that I addressed in voir dire, that the state in their indictment charged Adrian with conduct of endangering, but stopped that conduct at the point when the shooter entered rooms 111 and 112. all of these photographs and everything else are from things that happened after the shooter entered rooms 111 and 112. So they have limited, what they have done is they have limited the conduct for which Adrian Gonzales can be criminally responsible to up to the point that the shooter enters the room. And they've done that in their indictment. So if their argument becomes, well, these are somehow necessary for our proof, as we've said, they can discuss the fact that these children were killed and cause and manner of death. But in their indictment itself, it stops Adrian, whatever they're alleging he was doing criminally, which means that after the shooter entered 111 and 112, Adrian's not being charged with any of that, with endangering or any of that criminal conduct or anything else. So, as I said, he's not being charged with shooting these children. He's being charged with an omission that puts them in danger of being shot. But the indictment clearly does say that it does clearly stop at the point before the shooter goes into the room. That's important because, and I think the state will agree, that these children were all killed or injured after the shooter entered rooms 111 and 112. And with that,
All right. Who's going? Ms. Mitchell? Okay. I assume you have these cases. I'd like for you to specifically address what's been highlighted in these two cases. In his offer to stipulate and ultimately his argument about the limitations on the indictment. But those cases seem to be fairly on point about, I think everybody can agree, these are horrific photographs. I've seen a lot of autopsy photographs. These are horrendous, not so much by the nature of the injuries, but by virtue of the ages of the victims and the innocence of the victims. So certainly there's no doubt they're prejudicial. My question is, can you address the probative value outweighing the prejudicial value, their offer to stipulate specifically in light of those cases, and the limitation in your indictment that Mr. Gauss has argued? So, Mr. Turner, you may proceed.
And if I could, I would start with exactly where he ended, and that is that the indictment ends with the gunman entering 111 and 112. The indictment includes, after the gunman entered rooms 111 and 112 and shot at a child or children in room 111 and 112. And so we have a fundamental disagreement about what the state has accused this defendant of doing. We've accused this defendant of being aware that children are in imminent danger and failing to act in the face of that imminence. And it's the state's position that we're not talking about one shot put the defendant on notice, not two shots put the defendant on notice, but the repeated shots at children at a Robb Elementary School over a number of minutes is what caused this. Our cases that support that proposition are when kids, other child endangerment cases, when one child is injured, evidence that that child is injured is admissible to prove that the next child is in danger also. These are
case law.
Excuse me?
Did you say case law?
Case law. In the interest of EW, I believe. Interest of EV. And I have excerpts of that I'll provide for the court.
All right.
But in that case, it was one child was injured. They introduced evidence of that child's injury because they said that was proof that the other child was in danger of being injured. So as each child is injured, another is also. I want to talk about the concept of adults and children for just a second. And we can all agree, I think it's human nature, I think the nature of child endangerment is that we give special attention because we understand that children are fragile, tender years, and for them to be hurt is disturbing to all of us. But are we to now rule that adults can be murdered and the results of that can go to a jury? Children don't get that same protection by a court in Texas. A child gets injured, but because it's so horrible, the very nature of what makes the defendant responsible for a horrible crime, we're not going to allow the jury to see the results of that. And that's exactly what the cases on photographs of autopsies and crime scenes is about. A defendant is responsible for the conduct that he causes. And in this case, it's the state's position that he was compelled to act upon hearing 60 shots into children, and it was the compelling nature of that and his failure to do that that makes this such a significant crime. We're not talking about one shot and one person. We're talking about 29 kids, 19 of which died. Many of the others are injured. Each one of those children have the right to have their injuries depicted in the absence of Adrian Gonzales acting in the face of that information.
Okay, do you want to address the relative probative value versus the prejudicial?
The probative value is, number one, we have alleged that the gunman entered room 111 and 112 and shot at one or more children in room 111 and 112.
But what's the distinction between discussing it and describing it versus showing the actual photographs?
The case law says if you can discuss it, you can show a photograph of it.
Well, true, but you still have to consider the prejudicial versus the probative. So what do these photographs lend to the jury in determining any disputed issue of fact that could not be done equally by description and discussion?
I suppose the same would be with any injury case, Your Honor. Case law has said, though, that that is relevant. It is indeed relevant. So what we're saying is simply because it's children, because certainly people are killed with high-powered rifles in the state of Texas on a routine basis. So the fact is, what they are arguing makes it so horrible is just that the body is a younger person. And the younger person doesn't get the same protection that the adult does.
All right, would you, I'm not sure, are those microphones hot on the council table? Maybe pull that one over toward you a little bit, if you don't mind. Whoever's going to be speaking, maybe get a little closer. Mine will test it on, I assume.
It works good.
Judge, from the very beginning, we
Bill, you
said...
got to turn it on. You push that little button right there. There you go.
Should be a green light.
Yeah.
From the very beginning, we've tried to explain that the whole case of child endangerment puts people in a different situation. Adults are required to act differently when children are in danger. And it's because of the compelling nature of what bothers us about children. It's the whole reason we have child endangerment statutes.
All right, thank you, sir. Final rebuttal, anything? Mr. Goss?
Yeah, Judge, it's just to point out that even Mr. Turner said that in this, are we going to say in the state that adults can be murdered and we show their pictures, but children can't be murdered? If Salvador Ramos had not been shot in the eye and killed, shot by police officers at the time, and he was sitting in that chair, 100% all those pictures would come in because that is his conduct and that is what he did. This is not a murder case, and that's not what they're trying. Their indictment has limited it, and because we're asking you to take those things into account, because a person who has actually done the things and made the choices of where to shoot the children, where to aim the gun, of what kind of gruesome injuries to inflict upon those child, regardless of what the state is alleging, they cannot say that Mr. Gonzales was like that he made those choices, because nobody else made those choices but the shooter. And then, as the court's saying, we are willing to stipulate, but additionally, every person who testifies will be able to testify as to the injuries, the death. That's the only probative value that it has, and the only other thing that it can do. Only other thing that it can do is inflame the passions of the jury, and as we said, it would. And as the court has seen in the evidence, it's one of the most gruesome and horrific things. And not only just if you just took each child, but in total, like all the children, the 19, especially in the autopsy, if you take and then multiple pictures of all the children, that adds up as well. And so, of course, what the state would say that is, I'm sure, is that, well, we can't leave a child out, so we need 3 pictures for 19 children, which then becomes this cascade of horror. And are we able to be sure that his due process rights won't be violated? Are we able to be sure that in that cascade of horror that that's not going to irrationally affect the jurors' minds and make them so angry at the defendant that they don't make their decision based on the law and the facts?
All right, for the purposes of the opening statement, I'm going to deny the motion in limine. I'm going to find that my review of the photographs, that the probative does outweigh the prejudicial. However, I am not admitting the photographs at this time. Having gone through them, there are several that I may sustain an objection to, and they will not go to the jury. But for purposes of the opening statement, I am denying the motion in limine. But I'm reserving my right to exclude many of these photographs at the appropriate time.
Yes, sir. May I approach with your cases?
Yes, sir. Thank you. All right. Ladies and gentlemen, how many do we have on jurors? We have more? Okay, we have
Yeah,
the...
it wasn't the sole thing of our motion, but I know that the court would like to get started. We believe that the state's going to offer testimony of how this emotionally, mentally affected. We just asked the court grant it now, and the state just be asked to approach before putting victim impact state testimony as far as emotional, like the emotional or the mental effect that this has had on the parents or on the children who survived or anything like that, which I think is pretty typical. This would be victim impact testimony. We're asking that be limited. That would be the other issue.
Mr. Turner.
Well, first of all, child endangerment is both physical impairment and mental impairment, and we do intend to bring experts to say how the children were mentally impaired, the survivors were mentally impaired. As to the impact on the parents, we don't intend to bring any of that in. It's not about impact. It's about were the children endangered. Mental impairment is one of the ways children are endangered, and that's the only reason for bringing it in, is to show the PTSD, the mental impairment from the event.
Your Honor, I'll just in brief rebuttal. I have not seen, and we've looked, I've not seen any case law where mental impairment has been defined like that. Mental impairment is talking about, you're talking about like actual impairment of their mental faculties and processes, and being able to, it would be like an injury that caused it, not a psychological impairment, which definitely is terrible, but that has not ever been interpreted that I have seen, and I don't know any case law from the state that they can put on victim impact testimony and evidence about psychological and emotional impairment in order to make it fall under mental impairment in the endangerment statute.
All right, for purposes of, as we all know, a motion in limine does not preserve any error, but I'm going to grant that motion in limine, and I'll ask the state to approach and proffer any of that testimony so we can have a hearing outside the presence of the jury as to its admissibility.
Yes, sir.
Anybody have any other matters before we bring the jury in for instruction?
We have a few minutes to go to the restroom.
And I do have one more issue that was part of the motion. And this is something that we typically talk about. It's a motion we typically do in that victims are, the word victim, these children are clearly victims. And of course, everybody at this table and everybody on the defense knows that every child who was hurt, the children who were not hurt, the children who were in different rooms are all victims. Every teacher there, every adult there, victims. However, what the nature of this case is to determine if they are Adrian Gonzales's victims. And so we would ask that the state be limited to calling them the complainants or the victims of Salvador Ramos, unless and until at such time as he is convicted. But as I said, there is no dispute that they are, and I'm not trying to dispute it, but we are disputing that they are victims of my client and our client. We are saying that they are definitely victims, but of somebody else. And so we have done that. We have put those in and put those types of motions in before because we do believe that it could have a tendency to affect the jury by them being referred to in that way before he's been convicted or before it's been established that they are his victims. If that makes sense to the court.
All right, Mr. Turner.
Your Honor, Sire versus State, CYR, is the proposition that two people can be responsible for a child being victimized, the person who does the injury and the person who has the duty to prevent the injury. Both can be responsible for victimizing the child. So his whole concept that these victims are not victims of Adrian Gonzales is completely contrary to what the law is.
Well, no, the law is he's presumed innocent unless he's proven guilty beyond a reasonable doubt to all the elements. All I'm saying is that and that has not been established, obviously. So, and I agree that you can have two people can cause an injury, but they have not proven beyond a reasonable doubt that Adrian Gonzalez's omissions are responsible for any of the injuries of the children. And so I want to make clear, I am not disrespecting them, that I agree that they are victims, but they are victims of Salvador Ramos. That's been 100% clearly established at this point.
How? There's no evidence on that either, Your Honor.
Well, I think they'll stipulate to it. I think they'll stipulate that they are victims of Salvador Ramos. I don't think the state is going to contest that at all, and we're obviously not contesting that either. But I think ultimately is that their whole point is what they want to do is say that they are victims of Adrian Gonzales before they prove beyond a reasonable doubt to the jury that is true and that is a fact. And so with that distinction, I would ask that the state refer to them as the complainants until and unless they are able to secure a conviction. And then, of course, if we went to a punishment phase to the court, they can, of course, that's just kind of how that works. As far as them proving it, and I know the court knows that. We're just trying to prevent any danger of unfair prejudice or the jury being influenced improperly to believe that before they've proven it that these children are victims of Adrian Gonzales.
Okay, well, I'm going to sustain the motion in limine to this effect. They can be referred to as victims because they clearly are victims, but they cannot be referred to as victims of the defendant until and if that is final argument where you have established that beyond a reasonable doubt and you wish to argue that to the jury. But they can be referred to as victims, just not specifically as his victims until that is proven, if it is. Okay?
Yes, sir.
Mr. Goss, I hesitate to ask, what else?
That was it. I mean, we had a kind of a boilerplate prior convictions, prior bad acts. I don't believe there are any. They haven't given us any 404B of any of that, and so I don't. It's just if they believe that there's some prior bad act of our client, we just ask they approach first, and I think they would agree.
Well, that'll be granted approach if that arises.
Yes, sir.
Okay, so before the jury comes in, ladies and gentlemen, spectators, media, I know the media has agreed to some fairly strict rules, and we have a written decorum for the media. I've had several hearings in Uvalde, and I've had spectators, family members, victims in the courtroom, and they have behaved very well. But because of the nature, now that we have a jury impaneled and sworn, I will tell you under the Nueces County local rules, if there is an outburst or some sort of a problem in the courtroom, there's not going to be warnings. It will be removal for the remainder of the case. So please be cognizant of that and honor that, because we have to maintain order, and that is what their local rules demand. So let's take 5 minutes and we'll get the jury in.
Yes, sir. And just while we're on that break.